My first question to you is, so why did you feel the need to clarify your resignation, even though the term of the executive committee had already come to an end?
Well, we were a caretaker executive committee, and as leader of that caretaker body, it was, my legal and moral duty to ensure that the elections take place as quickly as possible.
Right.
In fact, I had started the discussion about virtual elections, fearing that physical election may result into very serious health issues in respect of my distinguished members, the election officials, and other candidates, representatives. So I started that process sometime in the first week of November itself. I had informally, sent a mail to all the members I wanted to, seeking their views about, holding physical or virtual election. I don't know, somehow that mail was not sent
Okay.
for technical reasons, I believe. And the
Okay.
mail was sent much later, about 2 weeks
Okay.
later. And the response that we got was very, very poor. Just about 30 or 40 people responded.
Okay.
And that clearly, made the pitch for virtual election.
Right.
So I called a EC meeting, and in December, I think 4th of December, if I mistake not, the EC took a decision to hold elections virtually. And at that time also, I had discussed one of the possible agencies as NSDL, because it's a semi-government company,
Right.
which was discussed. And I had told my colleagues in the executive committee to start dialogue with them to understand the modalities, terms of payments, etc. So I was very clear. And in fact, we appointed election committee on that day of three very, very respectable and distinguished selfless lawyers, Mr. Jaideep Gupta, Mr. Harin Rawal, and Mr. Nakul. So they started their work in all earnestness, and they in fact issued the scheduled election program. Election was to take place on 29 January. Now, when we went back for the purpose of permission to sign the agreement, which was a formality, I mean,
Right.
and, for sanctioning of expenditure of about 6 lakhs, which is not a big sum for virtual election, the executive committee, took a different view, and they did not approve of it. So in
Okay.
those circumstances, once you don't approve the agreement and once you don't sanction the payment, then naturally a semi-government agency won't sign with you,
Right.
which would mean that the elections could not take place on
Right.
29th January, as was declared by the election committee, which I felt was perhaps a big embarrassment to me personally. I felt morally that it would not be just for me to continue as the president, and so I
Okay.
resigned in larger traditions of my bar.
But so, what were the concerns regarding the virtual elections? Like, why did some of the members of the executive committee have reservations regarding NSDL conducting the elections?
I have no answer for that, because we had unanimously approved virtual election on 4th of December, and nobody from the executive committee had ever come forward with any other name other than NSDL. So
Okay.
I mean, and NSDL is a very reputed company. It has held similar such elections in other bodies also, and
Correct.
these are difficult times, and they
Yeah.
require different solutions.
Right.
Virtual election was a solution which we could have easily done, and I'm sure it could have been done. Even physical election, sometimes we have seen in Supreme Court, has led to certain unfortunate practices, like holding or throwing of parties, and
Yes.
giving food in even the parking lot on the day of the election, and inviting people and serving alcohol previous night and things like that. Those are the ills which take place in election in this country. We can't help it. So I don't think we should have had any serious fears about virtual election. But anyway, that's the decision the my distinguished
Yeah.
members of the election executive committee will now take. I believe they have decided to postpone it by some time. So let them do it whatever they think is appropriate.
Right.
But yes, I must say that there was no effort by anybody else to find any other alternative agency and to
Right.
proceed to hold the virtual election. Nor was any serious effort made to contact the members to find out whether members were uncomfortable with virtual election. I mean, the fact that only 30 or 40 responded to my mail suggested that they were in principal agreement with virtual election. And in fact, for a fact that when Supreme Court, after much persuasion by me personally, decided to have physical hearing and fix matters, out of 1,000 lawyers, only 5 or 7 lawyers agreed to appear. So that shows that my distinguished member friends in the association are reluctant to even appear for their matters. So for them to come to vote would have been, really too much to expect. So anyway, let's leave it at that.
So do you think the Supreme Court Bar Association could perform at its optimum level during the pandemic?
Well, I must say that the Supreme Court Bar Association, particularly my colleagues in the executive committee, as also my vice president, my secretary, my treasurer in particular, and my senior colleague, Mr. Chandaruday Singh, and many others did remarkable work. And I must say that, it's been a great, journey. COVID-19 has been the greatest challenge to mankind in our lives. I don't think we will face a bigger challenge than COVID-19.
Absolutely.
And because of the closure of the courts, the decision with which I don't agree, because of that, it has, impacted the very existence of legal community in a very serious way, especially of young lawyers, even certain, very aged lawyers who do not command very substantial practice. And they have really, I would say, they have been reduced to hand-to-mouth position. And therefore, to serve them with whatever resources that we could gather. And I must say, many of my colleagues, friends in the association were gracious enough to generally contribute on my appeal. Many people, contributed, and we could raise a very large fund, and we could therefore, give almost 700 plus members financial assistance, which was really, I would say, very satisfying work that the executive committee under my leadership could do. And I'm grateful to my colleagues in the executive committee who really spent, all these people used to be there in, during COVID-19 every day to scrutinize applications, to sanction them, to disburse the funds. It was amazing. Many of these, colleagues in the executive committee did it at the cost of their lives. And that is a great satisfaction. Plus, of course, we did many other things during this time. We had a wonderful, a relationship with the bench where we could, and the registry particularly, and wherever any member had a serious problem about, not getting their important matters listed, or not getting a proper hearing, or not having a decent virtual system for them. All those glitches, all those problems, I could bring it to the notice of the Honorable Chief Justice and especially the learned Secretary General. And I must say, every time any member approached me, and hundreds of them approached me in the last 9 months, the Secretary General and his colleagues were very, very helpful to extend the assistance and ensure that whatever difficulties were faced were removed as quickly as possible.
There is an increasing clamor of starting the physical hearings at the Supreme Court, but you can see that we are having a virtual interview today. Do you think we are ready to open the courts for a physical hearing at the moment, like with all the litigants and the lawyers coming across town?
Well, I think not only we are ready, but we must have physical hearings, and we must be able to regulate as well as we can. And I have no doubt that both the bench and the bar can sit together and work out the modalities of that regulation. In fact, the Chief Justice must insist for physical hearings, and only then large number of matters which deserve to be heard immediately will be taken up for hearing. And whatever one may say, the hearings on the virtual platform are not very, very satisfactory, not very, very satisfying, and not very, very enjoyable too, I must say, personally speaking. So I personally feel that there is nothing wrong. There are large number of bail applications they are pending. There are large number of applications, pending where pensioners are seeking reliefs from the court, retired people are seeking relief from the court. My own professor from Ahmedabad, who has been denied pension for last 30 years, along with thousands of other professors in Gujarat, I have been clamoring for hearing, because despite the fact that earlier matters, similar matters have been dismissed by the Supreme Court, in their matter stay has been granted and the state government is refusing to give them the pension, while the current honorable education minister of Gujarat, Mr. Chudasma, who is similarly placed to them, is getting the pension, though Supreme Court has stayed his judgment as well. So there are like this so many cases. I mean, so many members used to come to me and say that these are the matters which require immediate hearing. Many a times I did request the learned Secretary General to get them fixed, and he was kind enough to do it. But I mean, some kind of regulated hearing will inspire confidence and will allow young lawyers or those lawyers who really need to come back to practice and make some money and also do justice to their clients. That will take place. I think it's a must. It's not now a question of thinking about it. It should be started as early as possible, and I pray and personally appeal to the Honorable Chief Justice to do so.
Mr. Dave, it's been now 2 years since the 4 senior-most judges of the Supreme Court had raised certain concerns regarding the functioning of the top court. Do you think anything has changed regarding listing of the cases, particularly since you have also raised similar concerns in the past?
Well, I am afraid not. There are two things which are troubling me a lot. One is the constitution of the benches and allocation of matters to those benches, select benches by the Honorable Chief Justice. So every sensitive matter, I mean, I don't want to name judges, but every sensitive matter, even after Honorable Justice Bobde took over as Chief Justice, has gone to those select benches. And the result has been that most of the decision, if not all the decisions, have gone in favor of the executive. So I'm not saying that another bench would have taken a different view, but the fact that the matters are going only to select benches, which are politically sensitive matters or matters of grave public importance, that raises a very serious question mark. Besides that, I mean, despite, for example, my writing a letter about allocation of cases to Justice Mishra's court, and in fact, not just allocation, I mean, grabbing of cases by Justice Mishra's bench during vacation in that fateful year. Despite that letter of mine complaint, even during Chief Justice Bobde's time, 4 or 5 matters relating to Adani Group went to Justice Mishra's court, and all of them have been decided in favor of the Adani Group. I have nothing personal against Adani Group. In fact, I have known Adani personally. I have appeared for them in the past. But as a leader of the bar, as president of the bar, and as a senior member of the bar, as an officer of the court, it's my responsibility and my duty to point out to the Chief Justice that this is not done. This sends terrible signals. I mean, this court must not only be independent, but must appear to be independent. And this is where, I have a very serious quarrel that things are not happening in the right way.
What is your take on the recent spate of allegations being leveled against the sitting Supreme Court judge? There has been letters written to the Chief Justice leveling certain allegations.
Oh no, so far as that is concerned, I have no views, and I mean, I don't want to get drawn into
right.
it. It's for the Honorable Chief Justice to decide, and his brother judges to decide on administrative side. I mean, but having said that, I must say that yes, we have seen more than once. I mean, that many judges of the Supreme Court, particularly take very keen and I would say somewhat disturbing interest in the functioning of their own High Court and the subordinate judiciary in their own state, which should not happen. I think once you come to the Supreme Court, you should forget your own state and you should have no interest whatsoever in the functioning of your High Courts or subordinate court. And that's been happening for a number of years. And I think it's a very unhealthy practice. Difficulty arises because the Chief Justices of the High Court are not strong. I mean, right. 30 years ago, it would have been unheard of that any Supreme Court judge could have even dared to pick up a phone and talk to a Chief Justice about composition of a bench in his High Court or, appointment or transfer of a particular district judge. I mean, he would have been simply told that, Judge, you have no business to interfere in my administration. Sadly, today, we don't have those Chief Justices in High Courts. And that is why, I mean, everywhere we are seeing that system is falling apart. I can only share one thing with you, that when the Supreme Court decided to grab the powers from the executive to appoint and transfer judges in the second judge's case in 1992, the very foundation of that case was rested upon one or two important things. One, that the decision must be taken for appointing judges by constitutional functionaries fiercely independently. Two, that fiercely independent judges must be selected who are free from any kind of a political or economic pressures. Three, most important, you must select best from those amongst available. Now, these were the fundamental principles on which that judgment is based. And I must say with deep regret that for last 30 years, the very basis of taking away that power from the executive has been completely lost sight of. And as a result, more often than not, very, very disappointing appointments have been made. And as a result of that, it has a upward cascading effect that all those, poor appointments of High Court judges ultimately result in, poor appointments in the Supreme Court and poorer appointment as the Chief Justices of India. We have seen many Chief Justices against whom serious allegations have been leveled in past 2 or 3 decades. Now, therefore, it's very important for judges to realize that you wanted to tell the executive that there is political interference in your appointment and therefore we are doing this. And so they interpreted the word, consultation as concurrence in that judgment, which was rejected during the Constituent Assembly debate itself. And yet you took away the power with the pious hope that we will provide a better judiciary, more independent judiciary, more meritorious judiciary. I must say that that's not happening. And judges, there are overwhelmingly good judges in the court today. Everywhere in the country, there are outstanding judges in our high courts, in our subordinate judiciary, even in Supreme Court. And I would really beg all these judges with folded hands that they should now become active. They should mount moral pressure on the Chief Justice and the Collegium to ensure that henceforward at least the best appointments are made. Because if we are not going to have the best and the strongest judiciary, then I think there is a serious fear in my mind that democracy will be seriously undermined, rule of law will be seriously undermined, and constitution and constitutional morality will be forgotten for all times to come.
Those are the very insightful points, sir. Just a last couple of questions for you. You were recently representing a few farmer unions in the Supreme Court during the farmers' protest, and thereafter it was communicated to you by the farmer unions that they would not like to appear before any Supreme Court appointed committee. Why do you think did they have any apprehension before for appearing before any Supreme Court appointed committee, since you were dealing with them so close?
As I understand, look, their consultations with government for 8th round and yesterday was the 9th round haven't brought any fruitful results. It is therefore impossible that government at the highest level, if it is not willing to redress their grievances, that any committee, however competent this committee may be, that may be appointed by the Honorable Supreme Court, could really address these issues. See, this is not a matter of ironing out creases in the laws.
Right.
This is a matter about the very enactment of the laws and very survival of the laws. The farmers unions genuinely feel, whether they are right or wrong, nation has to decide, that these laws are a death knell. They sound a death knell for their very survival, their very existence. In those circumstances, with those emotive atmosphere, it is very difficult that such a committee can have any really meaningful contribution to resolution of the process.
What do you think is the way forward here? Do you think a committee can achieve a purpose? Or achieve, break the stalemate between the government and the farmer unions?
I personally don't think that a committee can really achieve that purpose. It would be appropriate for, as I said, on my own, that it would be appropriate that these laws are replaced before the parliament and parliament reconsiders them, because that's the only way forward. And I have, we are today having a majoritarian rule. And even within that majority, really the view of few individuals only count in this country. But I would still say that I'm sure at some stage the Honorable Prime Minister perhaps might like to reconsider the plight of the farmers and the sacrifices that they are making. See, nobody likes to sit in this cold for 51 days. I mean, thousands and thousands of people have been sitting here, not because they are happy about it, not because they are making a protest for the sake of making a protest. They are here because they fear for their lives. And it is therefore very necessary that, in a democracy, their voice should be not only heard, but their voice should be appreciated. And appreciating that voice, the government at the highest level, which is the Honorable Prime Minister, should really intervene and intercede and try and find some solutions.
So my last question for you. Recently there has been a trend to discourage Article 32 petitions, whether it be the Chief Justice of India or Justice Rohington Fali Nariman, and there have been questions raised as to what kind of petitions are being filed under Article 32 of the Constitution. So, do you think this trend is selective, or do you think the way we see PILs or public interest litigations is changing in the country?
No, there is no doubt about the fact, as Ambedkar had himself described in the Constituent Assembly debate, that Article 32 is the heart and soul of the Constitution. And it undoubtedly is, because if you have, there cannot be rights without remedies. And fundamental rights will become meaningless if they are not to be enforced, by the highest court, the Supreme Court of India, because it is the executive or the parliament which may violate the fundamental rights by their actions or by their laws. And therefore, the Supreme Court has to step in. Having said that, I would say that, the nature of PIL today is really fundamentally changed. It is the greatest weapon that Supreme Court had conceived to help the helpless. Today, I would say more often than not, maybe 9 out of 10 PILs, if I were to, I'm sorry if I were to little be blunt, are motivated. And as a result, you are destroying this very weapon which the Supreme Court found. But the responsibility, therefore, is on the shoulders of the Supreme Court, that they should weed out these irresponsible petitions coming, and they should concentrate on genuine writ petitions for genuine reliefs. Because there is no doubt about the fact that there is great injustice in society at large. That injustice may be at by the government, it may be by the bureaucracy, it may be by the police, or it may be by the rich and the powerful. But the vulnerable sections of the society need justice, and they need justice very quickly. Justice delayed is justice denied. And in this country, justice is definitely seriously denied. So, I have no doubt that, the exercise of judicial discretion by the honorable judges may be justified from time to time, but not in all cases. There are cases where, take for example, this case where this journalist from Kerala has been arrested by the UP government. That's a classic case where Supreme Court had to intervene and grant appropriate relief instantly. We all know that these completely bogus charges are being slapped against people. See, freedom of speech has to be allowed its widest expansion, and we cannot curtail it merely because state is not so weak that with some statement here or there by some comedian here or somebody here or some journalist here or some social activist somewhere, the state is going to be shaken. The state is on a solid foundation. State should not therefore be afraid of such people. The state should in fact encourage people to speak up. And it is, in democracy, the majority will decide whether those people are right or wrong during elections. But merely because the state has apprehensions, and we all know how police in this country and the investigating agencies file completely fabricated and false charges on people, that people suffer. So I I think the Supreme Court of India has a bounden, a pious duty to keep a watchful eye on the happenings in the country, and wherever they feel that the people's fundamental rights are being trampled upon, the Supreme Court must act, maybe at the instance of people or maybe suo motu, to ensure that these rights are kept intact and that they are not violated even for a single moment. If that doesn't happen, then I think Supreme Court has not lived up to the expectations which the Constituent Assembly or our forefathers, constitutional framers had, their hopes, to my mind, are belied by the way the Supreme Court is functioning today. And that really is not a very healthy sign or a happy sign for us.
Thank you so much for sparing the time for us, sir. And it was indeed very insightful. Thank you so much for being here.
Subscribe to our YouTube channel and click the bell icon.